Hi, thank you very much for joining us, those online and in the room, for today's Masters Monday, where we have colleagues from dispute resolution and labour law to explain all about the postgrad programs, what the options are, the degree structures, and then I've got a little bit of information for participants about postgrad funding. So this is always a great opportunity to come and ask your questions. Are you all in final year here? Final year? Yeah, okay. So it's all great to come during intermediate year as well to start thinking. It's nice to see that people are actually giving some thought to what lies after the LLB. So welcome everybody. We have today talking about dispute resolution, Monique Carls, who some of you may already have had, or you only, yeah, okay.
Yeah, online.
Okay. And Prof. Lisa Bosman, who comes, I think, once a year, twice a year.
Sometimes it feels, this year it's 3 times a year.
Sometimes 3 times a year to do short teaching blocks with postgrad dispute resolution. And then we've got Prof. Rochelle Leroux, who is our labour law expert, and then a younger academic who's joined us more recently, Cecile de Villiers, who will also be contributing on labour law. So I am going to hand over to dispute resolution to crack on, please.
Sure. So welcome everyone. This is really meant to be an interactive session. Should you feel like I want to scan, like, okay, I'll answer today. It's really meant to be interactive, so please do ask questions, whatever's on your mind, whatever you've been thinking about, whatever you're curious about. And I'm really happy that, you are thinking about what you're going to do in the next 2 to 3 years. And for those of you who are graduating, not too long from now, it's fantastic that you are thinking about pursuing postgraduate immediately following your studies. Because when you start working, it's really difficult to come back to complete a postgraduate degree. Right, so Lisa and I will be speaking about dispute resolution. And as the word says, it's dispute resolution, how to resolve disputes differently other than the normal way, the conventional way of litigation. So in dispute resolution, we focus on 3 specific types of dispute resolution. The first is negotiation, the second mediation, and then arbitration. Okay, so Kellen is the only one who did dispute resolution with me this year. And in that course, that's an elective course, where we basically touch the iceberg on each of these 3 processes. But in a master's, in a postgraduate diploma, we delve deeper. So you have 12 weeks of spending, you have 12 weeks of looking at what negotiation is, unpacking that, what mediation is, unpacking what that is, as well as arbitration. So this course really is for everyone and anyone. I always say conflict is an inherent part of our lives. And so this course really teaches you how to resolve conflict amicably, cost effectively at times, speedily, and that is what we need in our justice system. You would have heard if you've done civil procedure, the court rolls are overloaded. To get a case, it takes 2, 3 years, 10 years plus. So, appropriate dispute resolution looks at other ways of resolving disputes. Okay, so this course really is for anyone. Why is it valuable? It's a one-of-a-kind type of program. You don't find this LLM or postgraduate at many institutions in South Africa. So we are one of those few faculties that present this course over 1 year. Ideally, you can do it over 1 year. And like I said, it appeals to everyone, whether you're a graduate, whether you come from an HR background, whether you want to become a commissioner of the CCMA, whether you're a teacher, whether you're on arts and entertainment, it's really for everyone. And of course, we have a lot of international students also completing this program. So if you do partake in this course, you amongst the international students. We have a lot of European students coming from Germany, Sweden, Switzerland. So I really love that international flavor. And of course, all of these courses make you think internationally. So it's not only about South Africa and what happens in South Africa, but we think globally. Okay, so that is what makes this program unique. And as I said, there are 3 core courses, being negotiation, which is in the first semester, mediation and commercial arbitration is in the second semester. So those are your 3 core courses. So your elective, the recommendation always is that you take your elective in the first semester so that you balance your courses out. So you have 2 in the first and 2 in the second semester. Okay, and then there's 3 options for completing this master's. The first option is your professional master's, which is your 4 courses and your 4 research tasks. So your research task is obviously 5,000 words, 5,000 words each. Okay, so that's the research component. And of course, your research task topic is given by your lecturer. So you don't think of something unique. It's not a unique topic, but something that all the students doing a professional master's will write on. The second option is a master's with a minor dissertation. So those are your 4 courses with a 25,000 word thesis. Okay, so this thesis should be your topic. You should come to your supervisor with the topic. So potential supervisors would be myself, or I don't know, Lisa, do you supervise?
It's mostly volunteer.
Okay. So the other, the lecturer that's part of this course is Dr. Fidel Adams, but he's currently on sabbatical, but he's also another supervisor that you could potentially approach with to supervise your minor dissertation.
Monique,
Yes.
could I ask you just to slow down a little bit
Sure.
and speak a little bit sort of, I mean, you don't have to look up, but project towards the mic. People are struggling a little bit online.
Sure.
So thank you very much.
Yeah. So the third option, ladies and gentlemen, is the full-blown dissertation. So your full dissertation of 40,000 words. Okay, we don't often get students to complete a full dissertation. So most of our students opt for option 1 or option 2, but there is an option 3 if you are keen on, becoming an academic or, just keen on research and writing. So then that's the 40,000 dissertation, 40,000 word dissertation. Are there any specific questions? I know I said a lot. Or a little. Yeah, Kello.
For the semester exchange program, how does that work with allowing student solutions?
So you must do option 2, which is the 4 courses, or at least, so you do the first semester 2 courses, and then the second semester you do a broad, but you have to do it with a minor dissertation. So the 2 courses that you will do is technically negotiation and your elective, and then in your second semester you will choose modules that are equivalent to mediation and commercial arbitration at the partner university. Okay, often depending on what institution you go to, they do not have mediation and commercial arbitration, so that becomes problematic, but we do give concession as long as you complete the points, as long as you have sufficient points, but you have to do that with a 5,000 word dissertation. And then we, of course, recommend that you start with the dissertation before you go, because when you do go abroad in the second semester, things can be. Yeah.
If we are just doing semester work sounds like beautiful and in principle, but just your personal advice, if we are looking to use this degree in South Africa, it's like I want to be a long-term commissioner at CCM, like my end goal.
Yeah.
Would it be better to rather stay here and do it through UCC in terms of the long term?
It's really up to you. There's preference, because when you go to the CCM and you're going to do their training anyway, so this will just give you a nice foundation, stepping stone to becoming a commissioner at the CCM. So I would say it's preference. If you want that exposure abroad, I would say go for it. Because again, like I said at the beginning, when you do start working, it's tough to take a year gap year to study. So do what you feel is going to make you happy, and you don't know what opportunities they are for you as well. Yeah, so do think big, think global. Hi.
I was just wondering, what do the electives options come with?
Sure. So because it's in the first semester, you're only sort of limited to first semester subjects in the commercial law area. So often students choose individual labor law because that's a nice course that couples with that. But anything, I would say anything within the commercial law basket, as we say. There are times where students want to look outside of commercial law and a concession is needed. And I usually say, if something doesn't appeal to you in commercial law and you want to do something in public law or private law, go for it. We just have to speak to the course convener of that specific course. Okay. Anyone else with a question? Anyone online with a question?
Are there any questions online? You can unmute and ask if you have questions. I have a question.
Sure.
Do you have more info to share?
Yes, I do.
Okay. Go ahead.
Yeah.
Thank you.
Another thing that's unique about this course, ladies and gentlemen, is that we marry, we relate the theory, what you read in the literature, we marry that with practice. So on a weekly basis or every other week, we conduct simulations, and simulations are essentially role plays, where now you've learned about negotiation, so let's practice negotiation skills. You've learned about mediation, let's practice that. So we give you practical opportunity, we give you opportunities to put that into practice. Okay, a lot of students, they don't like that at the beginning, but they learn to love it because you really get to enhance your skills, your hone your skills, communication skills, listening skills, problem solving skills. These are all soft skills that we don't necessarily learn in our undergraduate courses, except for dispute resolution. I think, again, Callum and Kota online can attest to that, and that's invaluable. Being able to practice those sort of soft skills, interpersonal skills that we all need in our personal lives as well as professional lives. Similarly, in commercial arbitration, there's a lot of classroom exercises, tutorials, group work. Again, students are hesitant and they resist it at the beginning, but you just learn to love it and it's part of the learning process.
Certainly in the commercial arbitration course, we throw quite a lot of quite formal theory, I mean, compared to the negotiation and the mediation course, it's by far the most formal in terms of like formal use of legal techniques and principles, right? So is it a way to tell more about that?
Sure. Yeah.
So, there are obviously multiple ways of resolving disputes, right? And so what the commercial arbitration course does is to focus on one of those ways. And that's focusing on resolving disputes by using an arbitrator who decides the dispute for those parties in a process that is actually quite formal. So it's less formal than litigation, but it's much more formal than the negotiation and mediation, and ends up in a binding instrument of reward that can then be enforced across borders. So what we do in the commercial arbitration course, because it's here in the LLM program, and we get a lot of international students following the courses, we don't focus a lot on South African arbitration practice. We obviously give you an overview of how arbitration is conducted in South Africa in the different contexts, but we focus on international arbitration. So anywhere where there are two parties, two companies of nationality who want to resolve a dispute through arbitration or conflict that crosses a border, that's an international conflict, and if the parties agree to resolve that dispute through arbitration, that is the method that we use. So we focus on the international issues, and what we try and do is to obviously teach you all the kind of main concepts in the arbitration agreement and how you draft it, what the arbitrators do, what their role and their mandate is. We'll take you through the arbitral award and how it's enforced. And we'll focus also on concepts like the place of arbitration, so the legal framework in which international arbitration operates. We'll also teach and also cover the international conventions on treaties that the international system of commercial arbitration operates in. And so that could be the sort of core topics and the core framework that is used for the course. And then we'll give you some specialized aspects, right? So we'll give you a couple of lectures on the South African international arbitration system, because it's a good example of the application of the United Nations standard system. Right? Similar to that, I will give you a lecture on the growth of arbitration in Africa. We'll do a lecture on risk management and investment in Africa. And towards the end, what we'll do is we'll move away from the commercial aspect, which really covers, sale of goods and building of transport of goods across borders, sometimes building infrastructure across borders. We'll move away from that commercial context into a context that is a lot more colourful and a lot more controversial, and that is investor-state arbitration, which involves arbitration between an investor from one country into another country, which may end up in dispute, but there's no dispute directly between the foreign investor and the host state of the investment. It's a much more controversial aspect of the field because it touches on all these public policy issues on the state's right to regulate, for instance, to protect public health or labour rights. It often touches on environmental issues. Sometimes it touches on human rights issues. So that is the element that we add into the course as part of our coverage of international dispute settlement.
Would you like to speak a bit about that?
Yeah, exactly. So, after many years of teaching in this format, we formed a unit called the Arbitration and Dispute Resolution Unit about 2 years ago. And it is to consolidate the teaching around all these different forms of dispute resolution and to actually reach out and create relationships with other organizations that can offer another dimension, right? So we have a collaboration agreement in place with the Permanent Court of Arbitration May, which is where I'm also permanently based. And we offer a fellowship to a graduate on this program who has active nationality every year to do a 1 year fellowship this year. We also have an agreement in place with the African Arbitration Association to exchange lectures and resources, which payments from the African Arbitration Association conferences. We're busy trying to pursue a relationship with the UNIFSA, which is the main commercial arbitration institute in Johannesburg. So, we're hoping to consolidate the existing teaching, perhaps from 2026, expand it a little bit. And so, one of the things we're considering doing is splitting off the commercial arbitration course into a commercial arbitration course and a rest of state arbitration course. These collaborations through the units give us also the opportunity to bring in guest lecturers from all these places. And also, we often have a colleague of mine who's from the PCA based in Mauritius and will come over and do a lecture on state versus state arbitration. And we also make use of practitioners, a couple of practitioners from Johannesburg who have a long-standing relationship with the program and have a really good sense of how it actually works in practice and give kind of guest lectures. And then be available also to talk to you guys about job opportunities and what it's really like to work in a law firm or to work in government or to work in an offer institute. So we always organize a mentoring session at the end of the commercial arbitration course. Invite 4 or 5 contributors based in law firms or in government or working after institutes to talk you through job opportunities and the different ways in which we can engage in the system of international arbitration.
Yeah, and just on that note, all of our courses, negotiation, mediation, and commercial arbitration, will always invite guest lecturers who are experts in the area. So that is something that also sets this program apart, is that we have experts coming to teach you on their area of expertise. And so you get to meet others as well and network with those guest lecturers. And that's our story. Any other questions?
There was one online.
Sure.
And it is how many international students are accepted per average yearly. So this is a Namibian who's got an undergrad in ADR.
Sure. So we don't have a cap at the moment on international students or national students. Before, this course used to be capped, but now it's uncapped. So we do give preference to the students who want to pursue a master's in dispute resolution, because there are times where students perhaps do negotiation as an elective, or commercial arbitration as an elective, but we give preference to students who want to complete the degree, the specialization. So there's no cap. There's no cap. If you apply and you're accepted, chances are, there's space for you.
And perhaps I add that, we've always had a mix of students who recently completed their LLBs and students who actually worked first, right? I quite like to have quite a few students who actually have some work experience, because particularly in a course that is as hands-on and as practically focused as some of these skills-based courses and commercial arbitration as well. It's very useful to have input in advance from students who who've worked in a law firm or have worked in government or have acted as judges or managed to and it's a very nice mix. I love the mix in our classes. It's very international. There's probably about a third or so South Africans, up to a half the max, and then the rest are all non-South African students, and they bring with them experiences of their own legal systems, right, and their own sort of expectations of what justice means, and their own understanding of civil procedure, and how that is different. And it creates a very nice atmosphere in the class for us all to work in the job.
No, that was the only other one online. I think if there aren't other questions in the room.
One
Few more from me. Firstly, I was wondering, other than obviously the dispute resolution courses, what final year electives do you recommend taking to lay a foundation for dispute resolution? And then my second question was, obviously in the year we've taken like 13 courses, and yeah, some require different types of thinking to others. So I was just wondering, in order to kind of see if our aptitude lies here, which courses that we would have taken already do you think have a similar kind of way of understanding or applying them?
Yeah. Would you like to answer that, since you've to answer the first question, the only course at the moment is the elective dispute resolution, which Callum has taken. So you could give some insight. And that's the reason why he's here, because he so loved the topic of us. Yeah, it's like, I want to pursue a master's, Yeah.
It's quite cool. It's sort of not like any other, like including intermediate. Yeah, I would say obviously do this in planning. Yeah, I have a bit of a weird restraining, but labor law is kind of, I would say, of the same niche, but not really. Like the reason I come up with dispute resolution is because it's completely different. Like it's not really, you're reading hundreds of cases that applying laws like a straight set of facts. It's very practical, but also academic at the same time. I don't know. I feel like it's teaches you a lot of that. Like especially, I love the practical aspects of the events that I'm taking the master's program. I think that's just super helpful because I don't know. I don't like, you can read something in a textbook and sort of remember it. Once you read something, comprehend it, and actually perform it, and then your understanding is so much more thorough. And that's why I'm very sad.
It's a skill you attain, communication, like I said, active listening, problem solving, how to brainstorm, how to work in a team. They have to work in teams on a weekly basis and get to learn about their colleagues and from their colleagues, and so make lifelong friends in the process. But it really becomes a lifelong skill that you take with you. Whether you end up in this field or not, it helps you in your personal life, professional life. And then, of course, civil procedure touches a bit on what we do, but it doesn't go into as much detail as what we do in the elective, and then more so in the master's program.
Well, for international arbitration, civil procedure is probably like the one course that is most useful. Presumably, it's a military course, right? So,
yes.
So you're doing, yeah, exactly.
Good, thanks. Should we head over to labour law?
Sure.
Thank you, Rochelle. Do you want me to share a screen for you? Please. You're welcome to do it yourself.
I don't know how to do it.
There you go.
All right. Good afternoon, everybody. Dispute resolution sounds so exciting that I'm not sure that you want to hear anything about labour law. I think it's very useful to have. To combine dispute resolution and labour law, but I think the big difference is that dispute resolution, as Monique has said, is a lot about skills. Whereas labour law tends to incline towards black letter law and specifically legislation-based law. So I thought I'd lure you into labour law by sharing a few recent events that I've picked up in the media. And the first one that I came across was a CCMA award, which is of no binding effect in South Africa, but nonetheless, the CCMA is a body central to labor dispute resolution. And in this case, they sided with Dis-Chem, as you can see from the headline. The employee in this particular matter was diagnosed with cancer, had surgery, and as a result had to wear a stoma, which is external to the body. She could unfortunately not continue with the same work that she used to do. They tried to accommodate her, but eventually it became clear that she wasn't able to do any of the jobs available at Dis-Chem, and she was dismissed because of her incapacity. And the issue that the CCMA had to decide was whether her dismissal was fair or not. Now, that brings us to one of the core concepts in labour, as I suppose the traditional black letter law subjects. In labour, it's about fairness as opposed to lawfulness. She referred the matter to the CCMA, and as you can see, the CCMA found that her dismissal for incapacity was, in fact, fair. Now, I'm sure that affronts your sense of fairness, but on the other hand, what is the employer supposed to do if they've tried all sorts of options to accommodate the staff member but was not able to do so? So incapacity is certainly one of the issues that we will cover in our program. And importantly, and this is where we overlap with dispute resolution, we do look at the unique labour dispute resolution pathways created in terms of the Labour Relations Act. And while the pathways might be slightly different in other areas of alternative dispute resolution, those core skills of conciliation, arbitration, mediation, negotiation apply in the same way for labour dispute resolution. So another interesting case, I actually shared this case with my LLB students last week, was about the Limpopo teacher who was not dismissed but suspended because he refused to go to a teacher-parent meeting because he had invigilation duties, something that we all object to but must do, although it's a very long and boring exercise. There was some dispute about whether the two meetings overlapped or not. Anyway, he was not dismissed, but he still has protection under the Labour Relations Act, and he claimed that it was an unfair labour practice to suspend him for refusing to do invigilation, or rather for refusing to go to the teacher's parent meeting while he had invigilation duties. The matter did go to the CCMA. They didn't find in his favour. Usually when it comes to this kind of issue, the arbitration award is final, but there is limited opportunity to take such a matter on review to the Labour Court. And this is how this matter came before the Labour Court. Essentially, the issue was whether the employer was entitled to discipline him, and secondly, whether the suspension was a fair penalty. There was some dispute on the facts. In the end, the Labour Court found in favour of the employer. It did say, regardless of the exact timing of the two meetings, there was sufficient time for the teacher to go to the teacher-parent meeting, and his refusal to do so was invited disciplinary action, and the 2-month suspension that he got in this matter was a fair penalty. The court, in fact, hinted that if it were to decide the matter at the first instance, it might have considered a more severe penalty. So the dismissal, I beg your pardon, the suspension for 2 months was held to be not an unfair labour practice, and the employer was agreed with on the way it managed this particular matter. Something I shared with Cecile, and Cecile will speak to to you in a moment. This is actually a matter that relates to a judgment that was handed down in the United States. Am I correct? And that's the role of artificial intelligence when somebody is selected for a job. Now, some of the AI, although they're not human, they also have preferences because they've been programmed by human beings. And in this particular matter, an applicant for a job claimed that there was unfair discrimination exercised by the artificial intelligence who did the shortlisting on behalf of the prospective employer. Perhaps Cecile can speak to you about this particular example in a moment. Point is, this is a type of issue that we will cover in our program. Then one that gave me great pleasure, although he's a former South African, I would be inclined to side with him, but for some reason I have difficulty doing it. This is an Irish employee who worked for Twitter. Now, I've wondered, is the name of this platform, is it X? Is it Twitter? Or is it X, formerly known as Twitter? Which one of the above is correct? But anyway, an Irish employee worked for the then Twitter and got an email from Elon Musk. These are our values going forward. Are you prepared to work with these principles and values? Click yes or no. And if you don't want to do it and work according to our values or these values, you will be regarded as terminated, will be regarded that you have resigned. So this particular employee did neither. He didn't click yes or no. He was still thinking about it. And the next thing, I think they had like 24 hours to click yes or no. And the next thing, he got an email from Elon Musk advising him that we regarded that you've resigned, please leave the office. So without taking any action, Twitter or X, formerly known as Twitter, proceeded on the basis that he's resigned. He took the matter to the Irish Labour courts, and as you can see, he got a substantial award. The conduct was considered as unfair. I do think, Cecile, if we transplant that to the South African situation, it will probably, maybe not the amount, but the same principles would be applied, and it would not be regarded as a resignation, because this particular person was regarded as resigned without doing anything. But I do think it will raise similar questions in the South African context. And then just something that I came across this weekend, Harvard, a well-known university in the States, settles a case on sexual harassment by essay-born professor. Now, what is interesting in this particular case, the students proceeded against the university. They actually didn't proceed against the professor who's actually now retired from Harvard. They proceeded against the university, and I'm wondering whether that same principle translates to South Africa or transplants to South Africa, whether it would be possible for a student who has been sexually harassed by a professor to proceed against the university based on some form of vicarious liability. And I'm wondering, and perhaps Cecile can also speak to that, whether there is provision made for that kind of conduct under our labor legislation. So these are the topics that we would typically touch on during the Masters in Labour Law. I thought I'd just share with you the formalities around the program. As Monique mentioned, we've got 3 iterations of the Masters program. There's the Masters by dissertation, which requires a 40,000 word dissertation and is supervised, and you don't do any formal courses for that master's. Then there is the professional masters, and as far as the professional the masters in labor law is concerned, the typical course structure would be as follows. There will be a core element, an elective element, and then also the research task. So the core element would consist of collective labor law, individual employment law, which I teach, and workplace discrimination and equality law. Cecile teaches collective labor law and workplace discrimination and equality law. And as you can see from the course codes, collective labor law and workplace discrimination are offered in the second semester. Individual employment law is offered in the first semester. Now, in addition to the 3 core courses, you need to take an elective. So your 4th course will be an elective, and it usually will be taken from the offerings in the Department of Commercial Law. But as Monique said, it's always possible with the help of a concession to look at the offerings in the other departments. I am going to come back to the collectives in a moment. Attached or linked to each of these courses is a professional master's task of 5,000 words. So for collective labor law, individual labor law, and workplace discrimination, as well as the collective, you will be asked to do a research task of 5,000 words. You're usually given the topic at the beginning of the semester, and it must be submitted by the last day of teaching of that particular semester. It is not formally supervised, the research task, but lecturers do provide technical guidance. And the useful thing about it is that you don't have to find the topic. The topic is given to you, because that is something that is often difficult in the case of a master's with a mini dissertation. Students are keen to write something, but it's not always easy to identify a topic. So in the case of the research task, we provide the topics. The only downside, I suppose, is that there is limited supervision. So that's the typical structure of the master's, the professional master's course. If we go to the master's with mini dissertation, it's very similar. As you can see, the core courses, again, collective labor law, individual labor law, and workplace discrimination. Once again, an elective. And as in the case of the professional masters, the popular elective in this program is negotiation. I think it's a natural fit with the labor law program, but it's also a first semester course, and your elective needs to be, or it's going to make the completion of the degree a bit more complicated if it's not taken through in the first semester. And then lastly, what is significant in the case of a master's with a mini dissertation is that the mini dissertation that you need to do, it is supervised, but you need to identify the topic, and it's slightly longer. It's 25,000 words, I think. So since the advent of the professional master's program, we find that fewer and fewer students are opting for this particular degree structure. As you can see, in both the professional masters and the masters with a mini dissertation, you need to take an elective from the commercial law program. That's how it's written in the handbook, but as we mentioned, concessions are possible. So from this list, obviously not collective labor law, because that is one of your core courses, not individual employment law, and not workplace discrimination and equality law. You need to elect one more course as part of the program, and obviously your choice is further limited by the fact that it's preferable for it to be a first semester course. So on that note, I think I've given you a hint of what we do in the individual employment law. Perhaps I should just recap. Typically, we look at the dispute resolution pathways. We look at the meaning of employee. We look at the various forms of dismissal, of which incapacity dismissal is just one form. We also do misconduct and retrenchments and transfers. What is different from the LLB final year course is that in individual employment law, we only, as the name suggests, we only focus on the individual issues, whereas in the labor law LLB course, we look at the whole spectrum. But for purposes of the program, we've subdivided it into various courses so that we can go into greater detail. So I'll ask Cecile just to tell you a bit more about collective labor law and workplace discrimination.
As you know, those two courses are offered in the second semester, so collective labor law and workplace discrimination. And just to give you a little bit of an overview of what we deal with in those courses, like Michelle mentioned, the LLB at final year level comprises of individual employment law, collective labor law, and workplace discrimination. So you can imagine in 6 months, there's not a lot of time to really unpack every single aspect of these courses. So for collective labor law, we look at the history of collective labor law in South Africa. So everyone always thinks, oh, I'm not interested in trade unions, so maybe I shouldn't take this course. But we look at a lot more than that. So collective bargaining is a massive part of that course. And that is important for example, kind of you who are interested in negotiation and mediation aspects of an LLM. How the collective bargaining process works, what we collectively bargain over, and who the parties are that are involved in this process. That's always important. And I think what makes the collective labor law course interesting is we can't divorce it from the political and economic reality in South Africa. So it's always important to take into account the context in which we collectively bargain. And I think that makes collective bargaining in South Africa exciting because we have such a unique context. So those are some of the things that we look at in the collective labor law program. And then for workplace discrimination, we cover quite a few topics, but we start off looking at equality law broadly, and for example, what does equality mean, and a more philosophical approach to equality and how we understand it in our particular context. And then we look at the framework in the Employment Equity Act. So we unpack the mechanics of unfair discrimination in the Employment Equity Act, and then we also consider affirmative action. And like Monique also said, we invite guest lecturers, especially from practice, telling us what are the tricky points that people struggle with the implementation of, for example, affirmative action in practice. And I think even if you end up, whether you're an attorney or a commissioner or working in a corporate, maybe not even in a legal context, it's important to have this broad background of labor law, because labor law is always practical and important in any workplace context. So I think especially in the case of workplace discrimination, it gives us that opportunity to spend 6 months on the type of issues that we experience in the workplace, and which all of us will face some point or another in our careers. So I think that is a really exciting and fun course. So just to give you an idea of how the coursework works. So for workplace discrimination, what students will choose their own research topic. So as you know, in the Employment Equity Act, we have 19 grounds of discrimination, and of course not all of them will be covered in the different seminars throughout the semester. But you can choose your own research paper topic, and based on something that you are interested in the broad field of equality or in workplace discrimination. And then at the end of the semester, we have an opportunity where students can present their research to one another. We've also had quite a few international students, which makes the kind of topics that we deal with in this course interesting. And then we have this presentation seminar at the end. It sounds daunting, but by that time, everyone knows one another really well. So it's just a fun presentation and it's very informal. And then we also have the professional master's task, apart from the coursework component for workplace discrimination. And then the same for collective labor. So for this year, for example, we have 2 assignments and then also an examination in both courses. So the type of class structure you can expect, it's more a conversational approach. You have you do your pre-reading before you come to the seminar. And then the point is really to learn from one another, especially in the collective labor law course. We have people from trade unions, who work for trade unions, and practicing attorneys, people who have just finished their LLB, international students. So it makes for a really interesting conversation because everyone brings something different to the table. So those are those 2 courses for the second semester, and that's what you can expect. Do you have any questions about it? Yes.
I don't know if this is like specifically, or I guess I'm wondering from both dispute resolution and legal what the admission requirements for the LLM might look like, or like what sort of requirements you would meet for a guarantee of being accepted.
Okay. Maybe you can help me with that.
So this, firstly, for our program, we don't require an LLB, and I think it's the same with labor law. No LLB is required. So you can imagine the applications we get from all over students with all sorts of undergraduate degrees. What we do look at as a postgraduate, when I look at applications, I look at your GPA. More than that, I look at your work experience, and by taking the conversations, like we see, we have students who are attorneys, advocates, magistrates, we have HR specialists, we have trade unionists for both courses, I would imagine that's applying. So we look at whether or not you've got the work experience so that you can participate in the engagements and conversations. And of course, if you don't have work experience, you're just an LLB graduate, that's also okay. So the main thing is GPA and then work experience.
Generally, I think the GPA at 65 would be sufficient. But obviously, if somebody has studied 20 years ago, I don't think they even calculated GPAs at that point in time. But even if this person perhaps didn't perform well academically, but has since worked in an environment and gained specific, where he or she could gain specific experience around dispute resolution or labor law, then obviously we will take that into account. But generally, GPA of 65.
You need a good, well-rated motivation, Anita. You can't just, apply for the sake of applying. You need to motivate, substantiate, provide a good rationale for wanting to partake in the program. Often I get applications and it's criminology, it doesn't speak to what we are doing. So I want the student to personalize the motivation in it. And obviously it must be proofread. I don't want to see any spelling, grammatical errors, because that shows we look at that as a sort of extract of your writing and research abilities. So motivate, have good reasons for wanting to partake in either program.
If there are no more questions on this and there are none online, I'm going to give you a 30-second whistle-stop tour of funding opportunities that we know of. Thanks. I'll just do that. Okay, so top tips for looking for funding for your postgrad. Firstly, UCT's Handbook 14. It's a postgraduate funding handbook. There are all sorts of opportunities in there, and it is 100% worth your while to spend the time to trawl through and find things that are relevant or applicable for postgraduates in law. I'd say secondly, be flexible and kind of be open-minded about what sort of funding you're looking for, and don't self-exclude, rather have a look, pursue opportunities, apply, and rather be turned down than decide you're not eligible. Let them tell you. Obviously, keep your marks up. Funding opportunities are so competitive that in the end, the only thing left on which to include or exclude students is often GPA. That certainly applies for LLB funding for anyone who's ever applied. And then plan ahead. Callum, I think you can attest to the fact that the National Research Foundation funding deadline, you have to apply internally in order to get access to the National Research Foundation, but it closed on the 5th of July or something. And then they had tech issues and platform last minute collapse. So they extended it for a bit. But that deadline is for next year for postgrad for next year. So sort of start thinking, I mean, the fact that the intermediates in the room is great because you already, it just gives you just more scope to investigate and have a look for what's available. If you are on X, follow UCT Postgrads. They are constantly posting opportunities, new funding, new deadlines, scholarships from private donors, scholarships from institutions. It's just, I mean, they come up on my feed all the time and it's fantastic. It's like, oh, another opportunity, another opportunity. They're not all applicable for law students, but at some point you're going to find something that would be, that you'd be eligible for. Certainly gather as much info as possible, ask for help. You can make online or in-person appointments with the UCT Postgraduate Funding Office, and they can take you through stuff, point you in the right direction, alert you to opportunities and so on. Obviously, stick within the criteria and tailor your application to the criteria that you of the scholarship you're applying for. As Monique says, it's pretty grim getting applications for, because you forgot to take out the one name of the scholarship and put in the one you're actually submitting for. And then again, part of planning ahead is start looking today. Those are just contact details for the Postgraduate Funding Office, but if you just look for UCT Postgrad Funding, the things will come up. Yes.
So when you say postgrad funding, is it just for masters? Or is this also applied to looking for that DBA and they're not doing the postgrad work?
No, it's only for master's level study. Yeah, postgrad funding operates with honors and master's level. So not for the graduate LLB, but for.
That makes some sense because most of the opportunities only are not for the students at all.
Yeah. It's just a bit of a pain. The graduate LLB is managed administratively as an undergrad degree. So yeah, students in the program don't qualify for any of the things and often don't qualify for the things the undergrads qualify for, like NSFAS funding. So yeah, it's a sticky one. But the Postgrad Funding Office does not look at LLB students. Just to say that it is almost impossible to find funding during the year of study. So as far as possible, apply for things in the year before or leading up to. It's completely impossible to find funding for fee debt. So if you've missed the deadlines and you're already in your postgrad, it's not that there are no opportunities, but there are far fewer that are still open. As far as the faculty goes, we have a postgraduate scholarships committee who sit to review applications for quite a broad range of scholarships. I think they award probably about $2.5 million a year in postgrad scholarships for masters and PhD. They are trying to manage it so that the first call happens just before the year of study. So they're trying to get applications and decisions made in sort of November, December, January for the year. They sometimes don't spend all their money and issue a second call. apparently there's one that's out at the moment. I will check on that. But those are for this year. So the faculty scholarships they're sometimes able to issue a call during the year of study. But that's all on the faculty's website. There's actually a scholarship funding menu tab on the top menu. So go and have a look there, just trawl through, see what you can find. Most of those scholarships do not have demographic or geographic limits. There are a few that are specific, and you'll see in the criteria what those are. Most of the scholarships on the website are also in the faculty handbook. Not all of them, because new opportunities come up kind of on the fly, and then we add them to the website, but they won't be in the handbook yet. So just use all the resources and sources of info you can find. And again, just referring to the NRF, the academics will correct me. I think they didn't used to fund coursework programs, but they do now. Is that correct? Yeah, so that's quite a massive shift. Like you would only be able to apply if you were doing honours or masters by research or PhD, but that has shifted. So definitely worth checking out. But again, the deadline is you probably won't even have applied to do your masters yet by the time that deadline comes up. Yeah. So apply. Don't forget, NRF is kind of mid-year. Good luck. That's it.
Thank you.
Are there any questions about funding? We're going to say something.
Shaking is shaking.
No, okay. Are there any questions from anyone online or any in the room? If not, we are so out of time. So we're going to close the session. Thank you all very much for attending. Thank you to our academics for sharing your time and information. And we look forward to receiving your applications if you haven't already submitted. Thanks, everyone. Thank you to those online.